For over 30 years, we have been delivering you the most trusted, comprehensive, intelligent, and up-to-date news across every sector, every platform, every day. At Business News, we believe progress boils down to one simple habit. That is, what you subscribe to today shapes what you become tomorrow. Subscribe to success. Subscribe to Business News.
Hello and welcome to Legally Speaking, brought to you by Pragma Lawyers. I'm Mark Beyer, Senior Editor of Business News, joined today by Dirk, Branford, Special Counsel at Pragma, and Cosmos Liu, Associate. Welcome.
Thank you, Mark.
Okay, so the topic we're going to discuss today is dispute resolution, and we're going to run through the different options that are available to you and your business in dealing with any disputes that might arise. We'll be looking at the benefits and the advantages of each option, but also some of the disadvantages that you need to take account of. We'll be looking at negotiated settlement options and also talking about scenarios where there's a third party that's brought in. But crucially, before you get to a dispute, a really key consideration is to ensure that your contracts are properly set up in the first place. So Dirk, that's a topic for you to talk through. Let's give the listeners a bit of a rundown.
Yeah, thank you, Mark. Exactly what you say is that long before the dispute actually starts, you need to be sure that your contract is set up to deal with how you are going to resolve your dispute. And that comes essentially down to what's called contract management. And for parties to understand, and that is commercial parties to understand their contract as a governing instrument that enshrines their rights, their obligations, their liabilities, and how they have to act. So it's important to identify at an early junction in your contract life cycle, potential problems that you foresee in your contract. Are there contract ambiguities that you need to focus on? How will you deal with those issues should they arise during your commercial relationship? And then it's important to have in place in your contract mechanisms to deal with disputes or differences as they arise. How do you do that? For instance, what are your notification requirements under your contract? How do you notify? Are there time limits? To who do you write? And once you've done that, what is the process that the parties then have to follow to attempt to resolve that dispute? Now, a case in point is some contracts would contain a tiered level of negotiations where it would start off primarily at an operational level between two counterparties. If that doesn't resolve the dispute, it would then be elevated to a next level, and thirdly to the CEO level. And once that's done, then it empowers parties to take the dispute outside of their realm, so to speak, and to involve, third parties. So it's important to know that. What does your contract say about how you are going to resolve your dispute?
Okay. And then I think when we were discussing this earlier, you talked about the importance of having things in writing. So there's a clear record there of what has to be done rather than just verbal communication?
Exactly. I'm a big proponent of telling my clients that put everything in writing. Ink, to me, is very patient. You can always fall back on that. And with that, we mean, and what we mean is adopt a reasonable approach in how you manage your contract, communicate preferably in writing. That goes to telephone conversations as well. When you have a telephone conversation with your counterparty, follow it up with an email communication where you confirm the conversation, the outcomes of that, next steps, action points that needs to be taken. That is, down the track when there is a dispute, is a contemporaneous note of what happened at that point in time. So from an evidentiary point of view, it is for us as lawyers, it is a really important piece of evidence to say, well, this fact is evidenced through this note. My client wrote it right at the time when this issue was unfolding. So very important to, reduce your communications to writing.
Okay. And one more question on that, Dirk. I know in large construction projects, for instance, the contract often includes the details about the dispute resolution mechanism that will be employed. Now, how often does that occur? Is that only for the really big projects and big construction agreements, or can that occur at a smaller level as well?
No, I think generally for construction projects, it's developed so that those types of resolution and how you get to it is essentially contained within construction contracts now, and whether they be the large, the mid-size or the smaller ones, you normally find some way where the parties have communicated their desire in terms of how they will resolve their dispute. So, and then they generally tend to follow those resolution dispute provisions in the contract.
Okay. Righto, so in scenarios where a dispute does arise, Dirk, could you just give us a very high-level overview initially about what are the different options that are available?
Yes, and Cosmos will shortly enlighten us about a specific option, but generally, in broad terms, what we are talking about is negotiated options to settle a dispute versus options where the parties employ a third party that comes in to resolve their dispute. Now, the first term, the negotiated option, that involves the parties themselves as contractual parties and commercial parties that try and resolve their specific dispute. They are the main players in trying to achieve an outcome on their dispute. It's normally less adversarial. There's a commercial focus that remains, and they want to keep the relationship intact, resolve this issue, and then move on and obviously honour and perform in terms of the contract. So it's very much a situation where the parties move away from entrenched positions and they adopt an attitude of let's look at solutions moving forward. So that's the one part of it. Contrasting with that then, or let me say this before I move on, examples of that specifically would be negotiations where the parties enter into negotiations on a dispute, then mediation, which Cosmos will speak to, and then other forms, for instance, non-binding expert determination, which we won't go into today, but that is another form of that. Contrasting to that is your third-party resolution options, which a third party would come in, chosen or appointed through a process that would then resolve the dispute. And what we're talking about there is an adjudicator under adjudication process. Mark, you've just touched upon the construction industry. That is a very frequently used method of resolving construction disputes by way of an adjudicator adjudicating an application. Obviously then also we have the arbitration proceedings where an arbitrator would be appointed and would act as the third party person to decide and ultimately resolve the dispute. And then what we know obviously is our litigation processes where judges, magistrates would have the final say in a dispute and resolve that for the party. So what we look at there would be arbitration and litigation mostly.
Okay, righto. So Cosmos, let's talk a bit more about mediation then.
Yes.
I guess this is a scenario where it's that the parties are prepared to work together in a fairly constructive way, but they're bringing in a third party to help facilitate that process.
Yes, definitely. The main difference from what I can see between a mediation as opposed to an arbitration or even the litigation process, it's in a mediation, it's like Dirk said, it's a very party-driven process. You are in control of how the matter is being resolved. You are in control of what could potentially the outcome would be. And generally in a mediation, is whether by agreement of the parties or sometimes mediation can be conducted through court order. You will have an independent third party, which will be known as a mediator. The mediator will sit down with the parties. They will go through the key issues that are at hand. It would identify and assess the options and negotiate an agreement to resolve the parties' dispute. So the parties can do it by way of what we call an alternate dispute resolution clause in their agreement. So before the dispute even begins, when you are negotiating your contract or your agreement, you might want to have a clause inserted that in the event that a dispute were to arise, the parties agree to go for mediation. By doing so, you're avoiding the possibility of one party just jumping the gun and going straight to the court and filing a writ or statement of claim against you over a small issue. So this is what happens, and it's available in all levels of the court as well. In the superior courts, like in the district court and the Supreme Court of Western Australia, a mediation is an ordered process that the court will have the parties attend mediation after you have found your pleadings. And in the lower courts, that's usually done by what we call a pre-trial conference. A pre-trial conference in the magistrate courts is usually led by a registrar. You do have the option of asking for a mediation, where the mediation is actually led by a magistrate.
Okay, and in those scenarios, Cosmos, is it the court that appoints the mediator?
If it's a court-ordered mediation, then usually it will be a court registrar or a magistrate that leads the mediation. But of course, it's open to the parties to request for a private mediator. And that comes back to the part where it's a party-driven process. You do have the option of selecting someone that both parties can agree upon, which could potentially be of a certain expertise that might be able to assist your matter better than as opposed to a court registrar for that instance. And a very big benefit of a mediation is compared to a litigation that it's a without prejudice and confidential setting. So the parties are encouraged to speak as freely, as openly, as frankly as they want, because you are somewhat protected that anything that's been said in the mediation itself, it cannot be used against you if mediation were to be unsuccessful and the parties have to go through the whole litigation process. And it's also about the outcome. The parties, you might have some outcome that is much preferred as opposed to a monetary decision. So if, for example, if you were to go to court, then a judge or a magistrate might mostly decide that, well, for your breach, you might be allocated a certain amount of damages. But that might not be what you actually wanted. You might want to have the contract continue. You just want a certain specific issues to be resolved. And those non-monetary outcomes might be better suited. And you can achieve that in the mediation as opposed to being in a court setting. And of course, when it comes to cost, it's definitely a lot more cheaper than going to litigation, especially if you have an ADR clause in your contract. You might decide that let's just go for a mediation firstly. You might spend a couple of grand getting a mediator. There's be mediator fees involved. If you would like, you might want to hire a lawyer to represent your interests, but you can also freely take part in it yourself, or anyone, even the business manager or the director can sit in and just have a quick discussion. And most of the time, if the parties are amicable, you will arrive at a resolution. And without having to spend tons and tons of money and going through the lengthy court process.
So this might be hard to generalise, but in the sort of matters that you're dealing with, mid-sized commercial disputes, how long does this typically take? Can you generalise at all about that?
For mediation? Well, if the parties are formable to and agreeing to go to a mediation, as long as you appoint a mediator, that can be done within 2 weeks to 4 weeks. Like on the assumption that everyone's available at a certain date and the mediator of your preference available at that date. But if we were to go through a court process, generally it might take a few more months in the sense that you will have to file your pleadings. Sometimes the parties might want discovery to be exchanged so they can analyze their positions and assess the options that are available to them. And it will come after spending a bit of time and money if it were to go through the courts.
Okay. And are there some disadvantages that people need to be aware of when they're thinking about going into mediation?
Yes. Mediation, you need to come prepared and be willing to negotiate and put forward a settlement offer that you think is reasonable. If the parties come to mediation thinking that, nope, I'm 100% right, I'm not going to budge from my position, then sadly to say, most of the mediation are unsuccessful. So you must be ready and be prepared to compromise on your position. So that is one thing that you need to be aware of. Mm-hmm. And sometimes mediation, the outcome might not specifically be binding in that situation. The parties might reach an agreement, and unless you do sign a deed of settlement or release or a heads of agreement at the mediation, sometimes the party might just withdraw. So okay. you do have to make sure that if you were to go for mediation and the parties do in fact reach an agreement, at least have it recorded down in writing. So that's what lawyers prefer, always have things down in writing. Okay. I think that's very important. And look, there's no 100% success rate to mediation. You might spend a few grand, a few $1,000s on it, but it was unsuccessful, and you have to move on to decide if you want to take the matter to arbitration or litigation. So there is that consideration too as well.
Well, I guess there's no guarantees with any of these options, are there? Okay. So, Dirk, I think you've recently been involved in a matter which went to mediation, which you could use to illustrate the process.
Yeah, Mark, that's correct. And it actually touches upon a couple of points that Cosmo's raised, both in terms of benefits and, I think, slight disadvantages. This was a court-ordered mediation. My client and the counterparty was already in a litigation proceeding. Obviously, the mediation proceedings themselves are confidential, so I won't touch upon that, but I can, explain the procedure. And in that setting, the mediation was listed. It was before a court registrar, so the parties had to be present. What the other good thing is about mediation is, in order to try and resolve the dispute, someone from a litigating party that's got the power to actually bind that company must be present. In other words, someone that can say, yes, I'm happy to, for instance, resolve the dispute on this basis, and it is essentially done and dusted right there and then. You can't arrive there and say that, look, the party or the person with the actual authority to decide this dispute is not here today. That's not allowed. So in this scenario that I was involved in, we were there. I was acting for a defendant, my client, which basically made it difficult because the plaintiff held all the cards we felt in terms of, are we going to get to a settlement? And very early on in the proceedings, the other party, the counterparty, wanted to withdraw and essentially go home. And we seized upon the fact that no, we made ourselves available for the day. We were there to explore different options, and that the counterparty shouldn't be left off the hook, and we should, continue to try and explore options. The registrar agreed with us, kept them there, and I'm happy to say about 3 hours later, with offers and counter offers exchanged, we reached an amicable settlement that concluded the matter there and then. To Cosmos's point, we obviously were alert to the fact that we didn't want any comeback, so to speak, and we were able to, with the help of the registrar, to draw up some orders that essentially dismissed the matter there and then, and that was the end of it. So, a happy client that could walk out of there thinking that the mediation process in that scenario worked for him. It was quite early on in the litigation process as a whole. So before he expended a lot of time and money in the dispute, he was able to, to resolve it. So an instance where I think sticking to your rights in terms of the process itself, bearing fruit, in the end.
That sounds like a good outcome. Very, very good. Yes. Okay, so let's move on then to talk a bit more about arbitration, which is another option. And I guess the key thing here is that there's a third party that's brought in, but they are given decision-making authority. They are the one that makes the call. Is that a fair way to think about arbitration?
Yes, definitely. No, I think that's a correct description. And I think arbitration, although we say it's a party-driven process, and parties do have more choice compared to litigation, for instance, it is one of those processes where ultimately the third party, the arbitrator in this instance, would listen to the parties and ultimately deliver an arbitration award with an outcome where one party is a winner and another party would be a loser. So you get that winner-loser scenario. Arbitration, obviously, in relation to what disputes it can apply to, applies to commercial disputes more generally, and you would normally find that commercial entities would favour arbitration as a dispute resolution mechanism. You get both commercial arbitration in a domestic sense, so that is disputes within, say, WA or a WA foothold, and then you also get your international arbitrations that would involve international parties. Both of those, both domestic and international arbitration in Australia, are regulated by legislation. In WA, we have our Commercial Arbitration Act 2012, and at a federal level, we've got the International Arbitration Act 1974. Touching upon that point, why would I go to arbitration? Well, it's beneficial in the sense that where I've got a sensitive topic, or even not sensitive, but I want to protect my commercial interests, arbitration is a process that is confidential. It's private, it's not open to the public, compared to a commercial litigation matter in court, where the court is generally open to the public and you can walk in and you can sit in and listen to that. The big difference between arbitration, obviously, and litigation is that for arbitration to work, there must be an agreement between the parties to actually arbitrate their dispute. And that takes us back to negotiating your contract and your dispute resolution options, at the start, or at the start of your commercial relationship. Arbitration only works if there is an agreement by the parties to actually arbitrate their dispute. It must be in writing, and it could either be contained within the original agreement that they've got, whether that's a service agreement or the like, or it can be contained in a separate written agreement that provides for the arbitration of disputes. Absolutely agreement-driven, which is really important.
Okay, so once you've got that agreement in place, the two parties sit down. The process of finding the arbitrator?
Yes, there's different options. Again, it's party-driven. They can decide, do they want to employ a specific arbitrator? Do they want to employ an arbitration institute and appoint an arbitration institute that will then have under its auspices, different arbitrators? And then you can tailor-make essentially your arbitrator with specific knowledge and industry experience to your dispute, if that is what you choose. So touching on that point, so you can decide that. You can essentially decide the process that you are going to follow. You can decide the number of arbitrators. Do you want one arbitrator, or do you want a three-panel, arbitration panel to decide the dispute? It, as I said, provides ultimate confidentiality protection to the parties. Also, it seems to be perceived as less adversarial than litigation, but it isn't really, because in any high stakes commercial arbitration, parties normally adopt a kind of a similar approach to litigation. It is serious. It takes a lot of work, focus, and you need to be across your dispute and all the facts, in order to gain the most benefit from the process. In the sense of, well, what is the outcome in the end? It does provide finality of a dispute. The arbitrator, as we said, would ultimately deliver an award after he's listened to all the evidence. It's a very fair process. Each party obviously gets its time to put forward its case in the full. And after that, an arbitrator would then ultimately decide and render an award. Now, that award is normally final in the sense that unless there are serious issues with the process or the award itself, it wouldn't be appealable. So there are appeal rights to it, but it is limited in the context of of the arbitration process.
So you've run through quite a lot of benefits there from arbitration.
Yes.
What do you see as the main risks or the main downsides from going down that path?
I think, again, and I've touched upon this again, I think cost is an issue. It has become a bit of a I won't say litigation in another guise, but it is a costly exercise in the end, and that with that also comes time. It can be time consuming. Some big commercial arbitrations would run, for many months. Sometimes they go into years where they run. Going back to cost, obviously, compared to litigation, where you do pay court costs, but a judge or a magistrate ultimately decides your litigation dispute. With arbitration, the parties are also up for the cost of the arbitrator. And as I said, once you appoint an arbitration institute, normally those administrative fees that comes with administering the arbitration matter itself from that specific institute. So cost is definitely a factor as well.
Okay. And then I suppose when many people think of dispute resolution, they think about going to the courts, and that's the traditional pathway. So let's talk a little bit more about what are the options there, how that works, the pros and cons. So I guess for starters, there are lots of different layers for the court system. So just talk a bit about that.
So a very general breakdown of how the court hierarchy works in Western Australia. We have the lower courts, which is the magistrate court. That is for many criminal jurisdictions, and for civil jurisdiction, it's for claims under $75,000. If you do have a very, very small claim that is under $10,000, you do have the small claims division in the magistrate's court. But any sum that's above $75,000, the next step will be to go to the district court. And the quantum of the claim can go all the way up to $750,000. And any amount that's above that, you will have to go to the Supreme Court. Of course, the higher level of court that you go to, the cost involved with commencing the action and the filing fees, etc., will definitely be a lot higher as you do that. But sometimes also depending on the type of relief that you're seeking, sometimes it's not available in the lower courts, so you will have to go higher up. So that's that options, and the court procedure are generally very structured. There are a series of rules and guidelines of each individual court of the steps that you must take in order to progress the matter along. And usually it will start by commencing either a writ or a general procedural claim or the like in the various different courts. The plaintiff will have to file their statement of claim. The statement of claim have to set out the course of actions and the facts that they want to rely on in doing so. And of course, once that's been filed and served on the defendant then gets the opportunity to file their statement of defense, where they set out what their defenses are and if they agree or disagree with the items that's set out in the statement of claim.
So to touch upon that, Mark, which you mentioned earlier as well, as Cosmo said, you've got your pleadings and you've set out your case and the other party has set out their defence. But in between that, you also get interlocutory disputes, which is more about the procedure, where you take another party to task because they didn't follow a certain procedure under the court rules. So a very structured process, time-driven. Court deadlines, obviously, we are bound by court orders and the deadlines within those orders to produce documents. So a very structured process that obviously because of that reason then takes time and adds to cost.
And we hear stories about people, litigants with deep pockets that can, I guess, exploit the process to drag it out and perhaps even force the other party to come to a settlement. Is that a real risk? Is that something that you see? Or is the court sort of alert to that risk and endeavouring to crack down on it?
Look, I think there's definitely occasion where that would happen, and I think there's some recent examples within the our mining and resources industry where certain cases come up again and again in our courts, and there's been specific, decisions from our courts about that, endeavours and, doing that. But generally the court rules apply to everyone, and it's there to, ensure and enshrine fairness in the process, and obviously, the trust in our court system and the administration of justice. And I think with prudent lawyers, our registrars that administer the cases, our judges, a party that wants to employ that tactic would be found out, fairly quickly, and run the risk of being reprimanded for that attitude.
Yeah. Okay. So let's talk a bit more then about the benefits and disadvantages of litigation, then, shall we? I mean, clearly it's a very well-known, formalised, structured process.
Yeah.
I'll quickly go into the benefits of a litigation. You do have a very experienced and specialised presiding officer who might have been in the industry for 20, 30 years, and they will know the law very well, and they will be able to apply, they will be able to give the parties guidance and making sure that the issues itself are being resolved through to the best of the circumstances. And of course, the best thing about a court order is that it's binding. So unless a party seeks to make an appeal because they disagree with whatever decision was made by the presiding officer, the parties can rely on the court order to proceed into enforcement proceedings or anything that subsequently follows. So you do have that assurance that, yes, once the decision is made, unless it's been set aside, I do have that somewhat of a guarantee that it's been made for me. So I think that sometimes gives parties some kind of, they feel a bit comfortable about and comforting about that. And the court process is generally quite open, so anyone can attend the court. And if you do need any sort of assistance, the court staff are generally quite helpful too. There's a lot of materials available to guide any parties who wish to know what's happening with the usual court process.
And then on the downside, we hear this a lot, can be very time consuming.
That is unfortunately so, and I think that is as a result of the structured process that you have to follow, the pleadings, the discovery, you're putting on your evidence. Is a matter ready for trial? Then it gets entered for trial, and then it obviously depends upon court availability. So absolutely, time is a big factor in it, and it makes it a choice that sometimes impacts how quickly you will get to a resolution of your dispute. Add to that, then obviously, as we've got time constraints, that would normally add to the cost. Not only because the longer you run a matter, you have to pay the lawyers. It's lawyers on both sides normally, and they charge, for their time and their expertise. Apart from lawyers, obviously, there are other professionals that may be involved in your case as well. Experts of various fields that would provide their expertise and evidence in the matter. You have your lay evidence, your lay witnesses that may be involved in the case as well. I think then another disadvantage is that there's always uncertainty in litigation. It's very difficult to say to any client that you may not be at risk. In litigation, it is never an exact science. To go to court and to litigate. So that is another issue that you have to take into account in advising clients. And then I think the other one would probably be once the process starts, although it's a party's process, it is driven by, as we said, the court rules, time frames, and so forth. And coupled with that is, if you're the plaintiff and you commence the proceeding, you can't just decide on your own volition that you will withdraw it and there's no consequences. You will be up for consequences if you commence a proceeding and then decide not to, pursue it further, because you have put the other party to the cost of, defending your dispute that you've commenced against them. So those are issues that come in. And then there's normally a losing party, obviously. So compared to a mediation outcome or even a negotiated outcome, litigation has got a winner and it's got a loser. And some party, apart from losing the substance of the dispute, they will also be required to pay the cost, of the other party. The normal rule is the successful party is entitled to the benefit of the costs. There are limits, obviously, to the costs that you can recoup from the unsuccessful party, but in general terms, the unsuccessful party would, be in for the cost of the successful party. And then, lastly, as we know, it's a public process. Judgments gets published, so there are, especially in a business sense, there are the potential for reputational damage and publication of adverse findings and decisions in that context.
That's been a really good discussion. It's clearly not black and white in terms of pros and cons of those different options. So I guess we've given the listeners some insight into making an informed decision. In summary, are you seeing any trends in terms of what people are preferring, or in terms of the number of people that go to the courts, and as opposed to the other options?
I think litigation would always be a very popular option. It is there. It is a resource that can be used. As I said, there's a high level of trust in our justice system and the administration of justice. I think just a casual perusal of the Supreme Court decisions up to today for March would reveal there's about 63 published decisions. Now, take it that there may be some decisions that are not of a commercial nature in that number. There may be decisions that are mostly of a procedural, interlocutory nature, but it's still, it is still indicative of the popularity of litigation as an option.
Okay, and I guess people should think, appreciate the benefits that in Australia we have this well-established, independent, professional judiciary, and there are lots of jurisdictions around the world where you can't say that. So it's something we should appreciate. Okay, well look, thanks very much Dirk and Cosmos. I've really appreciated the discussion. This is the latest episode of Legally Speaking, brought to you by Pragma Lawyers. I hope you've enjoyed listening and learnt a lot from listening to this discussion. Thank you.